Actually, I feel like the man, you see, odd man out here, because I've had nothing to do with the entertainment business, but I have a vicarious relationship with the media because of having been in the judiciary more for a longer period as a judge than as a lawyer, but in all for about half a century. My only association with the entertainment business has been that my younger daughter happens to be associated with it. And I've met some of her friends here for the first time. And now I understand and appreciate a little better what she is doing. Because she has a justified grievance that I know nothing about what she does. As a matter of fact, media and judiciary have some things in common which make it very important that the area of regulation of the performance be addressed closely, particularly in the current times. And that I say for this reason also, that when you acquire great strength, then it is very necessary that you also realize the danger of its misuse, and it is best that you realize it yourself and self-regulate your conduct by practicing self-restraint, so that there is no justification for any outside intervention to regulate your conduct. You see, in one of the judgments while dealing with the right of the function of the judiciary, when I came to the conclusion that the judiciary had a more important role, I ended it by, you see, administering to, I may say so, to myself more than to my colleagues, because then I was in the system. I quoted Shakespeare from Measure for Measure, wherein he said, "Oh, it is good to have a giant's strength, but tyrannous to use it like one." Now today, nothing happens in this country in which the media and the judiciary are not involved. This vicarious association of the judiciary with the media is probably the justification for me to be with you here today. And also the reason why I could be persuaded to chair the National Broadcasting Standards Authority, because when the NBA people came to me and they said, "You tried to self-regulate the conduct of the judiciary while you were in that, well, with whatever success or failure, which of course is for others to decide. Why not help us to do it? Because we have decided to self-regulate our own conduct, particularly the content part of it." I thought for quite some time, and then, since I have always believed it's better to try and fail rather than not to try at all, so I said, if they want to self-regulate and they want my assistance, I should not be failing in my duty as a concerned citizen, because it concerns me as much as anyone else. So it is in this spirit that I accepted that honorary role, like many others in which I am involved after retirement. And it is in this spirit that I want to speak something about the content regulation, particularly these days when no day passes when throughout the day people don't talk of either the judiciary or the media, and most often both. Now, you see, the role of the media is the first thing I think we need to appreciate and understand, because then only the other things follow. Well, I'll come to the Indian scene later, but what are the basic facts? I think if we bear that in mind, it would be much better. Much earlier, the American statesman Madison had said, and I would like to quote a few sentences of what he said, which indicates the significance of the role of the media. He said, A popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy or perhaps both. And a people who mean to be their own governors, as we are, must arm themselves with the power which knowledge gives." Unquote. Now, in a representative form of government which we have, people have a participatory role in governance. And how can they discharge their participatory role in governance? Unless they have information of all the matters which concern them, so that they can make an informed choice as to what they need to, do in a particular situation. They have, therefore, the right to continuously monitor the functioning of the government, which means all public functionaries. Their right is not merely to vote at the sporadic elections, which have become more frequent now. Earlier they were visualized only every 5 years, but in between also to constantly monitor that. Now, how do you do that? There has to be, and therefore the focus on transparency, and you are seeing the impact of the Right to Information Act. Now, Right to Information Act does not confer a new right. It merely operationalizes the existence of an existing constitutional guarantee, which really is the source of the freedom of press. And that is Article 19(1)(a), which every individual has the right to freedom of speech and expression. And it is from that by judicial creativity, without any specific mention in the Constitution, the freedom of press or the media as a whole has been derived. And in the right to freedom of speech and expression is implied the right to know or the right to information, along with the right to communication. So all these combined give the media the right to do what they are doing and they are expected to do. In short, therefore, it is the media's duty to inform the people of everything of significance so that the people can effectively discharge their participatory role in governance. Now, from that, it is also flows as a necessary corollary that the right to inform excludes the right to misinform. And therefore, you see, it has to be information, because if there is misinformation, the impact of the media, whatever it says or disseminates, being so great and also instantaneous. In the case of the electronic media particularly, the damage done is much greater, and therefore it has to be very cautious to ensure that it does not misinform, it only informs. And information means not being objective, reporting the facts as they are, not mixing them with your opinion or giving them it till the way you want, because that is not reporting facts, and that requires therefore objectivity. So this transparency, which is necessary, is also necessary for accountability of all persons who are invested with public power. And it has been said, and that's how it has been understood. The freedom of press is not really, and mind you, in the Indian Constitution there is no mention of that, but it is derived from the people's right, that is the individual's right. Now, you see, but it can't be untrammeled, because rights and duties are correlative, and my right I cannot exercise in a manner that it may infringe on someone else's right. And therefore, there are certain duties, and those duties therefore bring in the concept of reasonable restrictions on the exercise of one's right. So this right to freedom of speech and expression of the media is no greater than that of the individual, and that is subject to reasonable restrictions. And in our Constitution, You see, it is expressly provided, 19(1)(a) is the right, and 19(2) specifies reasonable restrictions under certain specified heads. Of course, you see, so far as friendly relations with foreign countries, etc., is concerned, that, or in other words, national security. But in the interests of, in public interest, for the purpose, in the interest of decency, morality, law of defamation, contempt of court, etc., etc. Now, all these are relevant for in everything which the media does every day. You see, now morality is not confined merely to sexual morality; it is much wider. Decency. Just to give an example, you see, I mean, of course, I'm digressing slightly because to that I wanted to come at the end. But all the same, decency I would illustrate in this manner. Now, some time back, we had we have had so many bad incidents, but two very obvious which everyone knows. Now, Prashant Bhushan was beaten up by someone. Now, throughout the day, he was beaten only once. But then the media showed that beating continuously. And continues to do it even now. You see, Union Minister Sharad Pawar, poor chap got only one slap, but he is being slapped continuously. Now, is it decent? Is it necessary? You see, the question to ask is, you see, is it in public interest? Now, someone says, well, everyone doesn't see at one time, but you don't need to show a man being slapped every time. You see, I mean, it's enough to say that he was assaulted. That's good enough. Now, you see, now these kind of things are expressly forbidden. And one thing which the media needs to remember is that if you don't practice self-restraint and regulate your own conduct, then someone else will do it and would be justified in doing it. Now, recently there's a lot of furore over the Press Council of India chairman. Of course, I myself criticized him for the vituperative language which he used and asking for a danda so that he could use it, I mean, in the way he liked. But you see, but we need not overlook the bottom line. The bottom line is, and mind you, I mean, you see, I think the media should learn from this, that there's a large number of people, the public opinion, supporting what he says. Why? Because no one likes so many things which happen. Now, you see, these are all areas which need to be taken care of. Now, some particular things which I would like to mention which need to be media trials. Now, you see, media trials, the trial in the court has not begun, but then the trial in the media is continuously there. Before the trial takes off, you see, the trial here is completed and someone is convicted. And the next day, they say, no, not this fellow, the other fellow. Arushi murder case is the typical example. You see, now, everyone has been convicted and acquitted from time to time. Now, is that the role of the media? You see, forgetting that there is a legal aspect also to it, and you see, legal aspect is this serious contempt of court, because this interferes with the cause of justice. And not only that, you create a public opinion against someone which the court ultimately doesn't find to be justified. Now what happens to, you see, that, and supposing the court reaches the same conclusion, then the impression is that the court has been influenced by that. Now is that something which is desirable in a civilized system? That's not what the media is meant for. media, well, when I pulled up some of these media persons, and of course, which I keep on doing, unlike Justice Karju, I don't use redunda, but I certainly pull them up and tell them what they should not do. And you see, I say another thing, the use of language. Now, recently we have had that, you see, because all that is in public knowledge, therefore I'm using the names, otherwise I would not have. The media said, tainted Thomas, the gentleman who was appointed CVC, and of course, for a good reason, the court set it aside, because I believe, even otherwise I would like to believe that everyone, unless proved to be guilty, should be presumed to be honest and innocent. And many people from his fraternity have said that he is a person of, you see, great integrity. But the fact remains that he continues to be named as an accused in a criminal trial for corruption. You know, he may be, I would like to assume that he is innocent, but so long as the name continues as an accused, certainly he does not satisfy the test of impeccable integrity which is required for the appointment to that high office. And incidentally, you see, I am the cause of most of the trouble, because this expression also is used by me in one of the judgments, which is the test. Now, so you see, but the media said tainted Thomas. You have finished. I mean, you have damaged the man's reputation. When it's all right, you could report that Mr. Thomas, who is named as an accused, was appointed, and you may ultimately report the judgment that was. But when you say tainted Thomas, then you see that adjective, was it necessary for the purpose of reporting? Wholly unnecessary. And then you see, these days, the matter 2G and CWG, etc., whereas the media is to be credited for highlighting the misdemeanor in high offices, corruption at high places. Actually, the first instance was the Hawala case, which also incidentally I was the one involved in, you see, presiding over that bench. And that judicial process of continuing mandamus or monitoring is attributed to me being developed in the Hawala case, which is being followed. But more than what is going on in the court is happening in the studios. Every day there is a panel discussion. And the panel discussion, you see, is to ensure, and everyone knows, so I don't have to name, there's one anchor who speaks more than all the 6 panelists. And one day I told him, I said, look here, of course, Council of India chairperson, because he had abused certain high court judges in one of the high courts, and they didn't take any action. But I suspended the sentence, didn't send him to jail. But today I'm not too sure if I would have left you if I was there. And I said, you are lucky. Now, you see, people must, you see, what I've been warning them all the time. And I take this opportunity to say that because, after all, the media is very much concerned with this event. Now, what ultimately has happened, of course, I have myself said that was wrong. That's not the kind of decree to be passed. In the case of Justice Saman. So, you see, because that is a case, in the first, and the first thing is, well, with my experience, which was not short at all, both as a lawyer and as a judge, I am not aware of any case in which, what to say, of 100 crores, even a few crores has been awarded as damages. And even Bhopal gas tragedy, Upahar, I mean, all that. So 100 crores is absurd. I mean, there's no doubt about it. But, you see, and I also said in that in that connection, which may have been reported also, that much earlier when I was also in the court, Justice V. Ramaswamy of the Supreme Court, he was impeached, and there was in a weekly magazine a report of his impeachment, and instead of his photograph, the photograph of K. Ramaswamy. Now both were in the Supreme Court. Now anyone could easily be misled. But all of us, including K. Ramaswamy, laughed it out. We said we just ignore it because you say, and Justice P.B. Samant is a person of high integrity. I mean, no. And this news item really speaks of a sitting judge of the Calcutta High Court where P.B. Samant was never a judge. He had retired. This news item speaks of a sitting judge. The photo by some act of negligence, etc., of some lower functionary was published, scolding the person, publishing an apology which was done, I believe, etc., or a token amount of a rupee or 100 rupees could be understood. But you see, but the fact remains, what is to be learned from this incident? What is to be learned from this incident is the lack of due diligence which is important. Because it was the lack of due diligence which resulted in it, and due diligence is necessary before you publish anything which is likely to damage the reputation of anyone or invade the privacy of someone. See, the courts have been very liberal, and I personally have always believed in that and continue to do so. That's why, I mean, I criticize this judgment, even though I've been pulling up the gentleman for doing what he does every day. Now, you see, the courts have held, and that is the law in India also, that unless there is proof of actual malice, which is rare, or reckless disregard for truth, so that if neither of these two things are there, then even a defamatory falsehood published about a public functionary in discharge of his public duties is not actionable. That is the extent to which freedom is given, but that's not to be misused. And reckless disregard for truth has to be very strictly construed, not mere minor negligence of this kind, that because of the phonetic similarity between Samanta and Samant, some lower functionary pulled out a wrong photograph and published. So that margin is there, but the fact remains, why did it happen? I think that is what needs. It happened because of the kind of atmosphere which has been created. Everyone now talks. I mean, just because of this owner's duty that I've taken upon myself. Now everyone who meets me, he tells me, why don't you stop those people? They are doing this wrong thing every day, as if I'm responsible for all that. Now, these are therefore content regulation, and the biggest challenge, this is what I want to emphasize, is this. The biggest challenge is to erosion of this freedom of press, that danger of erosion to the freedom of press, which ultimately would impinge or impact on the right to freedom of speech and expression of the people. Because if this is not controlled, then there would be justification, which people have already started talking about, of, you see, outside intervention and regulation. And what would happen then? Well, I don't know how many present here are aware. Of course, Mr. Murari would be. I was a judge from 72, so at the highest level, and therefore before the emergency came. I saw what happened, and it happened to, incidentally, my High Court opened on the 26th of June, the very next day after the emergency was imposed. And again, fortuitously, the first batch of habeas corpus petitions were filed before me in the court, and I was the one who entertained them till my view was overruled later on by which led to the amendment of the Constitution. So I know, and therefore I am more concerned, what will happen if the government intervenes, steps in and tries to regulate. And that is why I had to say, when the present chairman of the press council spoke in that language, that I am reminded of the language which we heard from the then Information and Broadcasting Minister, Mr. V.C. Shukla, that kind. Because if the press is controlled, nothing worse can happen. And therefore the courts have even been liberal to this extent. They have said, even if you have to leave out a few noxious branches, leave them, but don't, do away with the tree, but then don't give an occasion so that people ready with an axe in their hand, step in to completely do away with the tree. That is the danger.